yesterday your lordship was asking for the written apartment matter FA for 62. On the last day, your lordship, 22 of April.
I have come to know that it has been posted post petition.
Yes, I have taken the consent from the opposite counsel. If lordship permits, we can.
No, we are just left with 1 week. We are just left with 1 week, not this side. क्या चीज़ का? क्या? BA. क्या हुआ? विटनेस नहीं आ रहा?
नहीं, वो चार्जशीट के लिए ऐसे ही चार्जशीट
From supplementary list of fresh filings, item 1, BA 3928 of 2026.
What is the allegation against you?
Hired somebody body in general setting, and the respondent's wife is the petitioner's wife is informed.
So what do you have to say?
Custody पे ही पहली इसके बाद वाली अलग से क्या था?
क्या कस्टडी पे क्या करने बताइए? आपका तो आपका डायरेक्ट एलिगेशन है आपके ऊपर. You have taken the victim to the jungle and then you returned and then
last scene case.
Last scene case नहीं है.
Also because the informant is alleging that he is suspect who has committed the murder of his brother. Actually, he has taken his brother from the house of his wife, and then after the
Let the case diary be called for from the concerned court. The counsel for the state is directed to file a counter affidavit in this case along with the criminal antecedent report of the petitioner. The stage of the case will also call for along with the आपका क्या काउंटर है? क्या है? काउंटर फाइल चलिए सर. We can give antecedent report. Case diary court से मंगाएंगे. Stage. Close this case immediately after vacation on 8th of June.
Condition item 2, BA 11822 of 2025.
Charge sheet has been submitted.
He's in custody since 27/8/25.
Charge has been claimed. It was kept for to find out whether the charge has been
That
claimed.
was the another case that is coming in the next week.
Okay.
This case followed me.
Where is the counsel for the state? Any video has been recovered?
That photograph is attached to the case.
Only photograph is attached. Any video has been recovered? कैसे ये बार-बार ये केस आ रहा है, हर बार आपको पता नहीं रहता? नहीं तो ये फॉर्मल अपीयरेंस है क्या आपका? आप मत अपीयर होइए. जो आप असिस्ट नहीं कर सकते तो अपीयर होने की कोई जरूरत नहीं. This case is being posted time and again. पासओवर का प्रेयर करना पड़ता है. देखिए सर, तीसरी बार अपीयर हो रहे हैं, 3 बजे आप आ जाइए बस, उसके बाद पासओवर मत. ठीक है, ये केस डायरी लीजिए. हमसे ये हम ये जानना चाहते हैं, फोटोग्राफ तो है उसमें तो ऐसा कुछ दिख नहीं रहा, कोई वीडियो भी मिला है?
Video was prepared by herself victim by the
That's right, but there is an allegation that it was made viral.
through the different mobile numbers. Jeet Kumar's mobile, that is mentioned.
तो देखिए,
From dailies for the Saturn 1, BA 8156 of 2024.
yes, why is this matter being listed?
This comes probably for the extension of time.
Madam, it's something very serious. FSL report is not coming. It's a case of 2024. Yes, I'm posting it next week. You file the FSL report in sealed cover. You get the FSL report. Where is the FSL report, madam? In this case, FSL report is not coming time and again.
It is a disposed of matter.
It is a disposed of matter. The case has come up for extension of time. And it also says that awaiting a FSL report. I am posting it on Tuesday in supplementary list. You just find out about the FSL report.
I will take it.
Okay. Post on next Tuesday. In the meantime, the Learned Counsel for the state shall file the FSL report in sealed cover on the next.
Some longer time.
Why longer time? 2024 का केस है.
But to meet the Saturday,
ट्यूसडे को रखें, ट्यूसडे.
File करना.
फाइल नहीं करना है, प्रोड्यूस करना.
I will.
You don't need to do anything. You just have to put it in seal cover and produce it to the court. Then I'll just, if you are able to do so, I'll ask you to produce it to the court concerned. And then I will extend the time. Okay?
Purpose filing item 2, BA 3782 of 2026.
Case of cybercrime 2, 3 and 4, 3 and 2, 3, 4. Arising from the same offense. 2, 3 and 4.
Charge sheet has not been submitted.
No. So after the case,
2, 3 and 4 is active. Counsel for the petition submits that these three cases arise out of same FIR and accordingly they may be tagged. Consequently, they are tagged in her together. Antecedent नहीं है किसी में. ये राहुल कुमार दास is a very famous person. और हर बार बोलते हैं इसका कोई antecedent नहीं है. I am absolutely clueless. Antecedent पे तो हमको बहुत सोच के देखेंगे. It appears that charge sheet has not yet been submitted. The Learned Counsel for the petition submits that counter affidavit and criminal antecedent report be called for, and in the meantime, it is all likely that charge sheet will be submitted as the petitioners are on custody since 9/3/26. 10/3/26. Considering the submissions, the Learned Counsel for the state is directed to file counter affidavit along with criminal antecedent report and also produce the case diary and also produce up-to-date case diary. The counter affidavit should indicate as to whether the charge sheet has been submitted or not. Suppose this case immediately after ensuing summer vacation on 9th of June. बाकी दोनों में आप ही हैं और somebody else is there.
Serial
You are there, but for the state,
serial very well.
what about others? You will convey it to others to file counter affidavit.
Yeah.
Item 5, DT.07.09.2026 of 2026.
Is reference in code point PA number 3775 of 2026.
Where is it listed?
On 15th of
BA number 3793 of 26.
3775.
अभी तो इसका तो यही है 379. BA number 3793 of 26. The counsel for the petition submits that this case be tagged with BA number
3775 of 2026.
3775 of 26, which has been posted on 15th of May 26. Let this case be tagged with PA number 3775 of 26 and be posted on 15th of May. Counsel for the state is directed to file a counter affidavit along with criminal antecedent declaration.
Item 6, DA.3796 of 2026.
Adjournment 4B ये रिजेक्टेड चार्ज फ्रेम हो गया 30 में 5 विटनेसेस एग्जामिन वो लोग सपोर्ट नहीं करते नेक्स्ट बिग क्वेश्चन
Trial and expedite कराया. That much I can do.
स्टेज ऑफ राइट
सब हॉस्टाइल हो गए हैं क्या?
सभी हॉस्टाइल हो गए नहीं ये हॉस्टाइल तो नहीं है कुछ बोले घर ये घर पर नहीं थे घर पर ये अकेली थी खाना बना रही थी उसी समय स्टेज ऑफ राइट
BA number 3796 of 2026. The learned counsel for the parties are present. The bail application has been rejected, earlier rejected of the petitioner in BA number 7181 of 24 by the order dated 21/11/2024. The petitioner happens to be the husband of the deceased who died within 3 years of marriage out of fire.
5 आउट ऑफ 13 5
आग लग गया था ना?
हाँ
Out of fire. The counsel for the state has opposed the prayer and has submitted that the trial is going on as per the interim order dated 13/6/2026. As 5 witnesses have been examined out of 13 charge sheet witnesses. The learned counsel has submitted, for the petition has submitted that the witnesses so examined have not fully supported the case of the prosecution and it appears that the incident was out of accident. After hearing the learned counsel for the parties and considering the fact that the bail application of the petitioner was rejected earlier on merits and the petitioner is the husband, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to SP of the concerned district and also to the director prosecution of complaints.
Item 7, DA.3797 of 2026.
Case of study since 14 to 2026.
Charge sheet तो नहीं हुआ होगा.
14 को.
छुट्टी के बाद रखते हैं क्योंकि चार्जशीट देखिए अभी तुरंत ही होगा फिर काउंटर एफिडेविट फिर ये सब चीज़
If
चाहिए.
not on that, charge sheet will
BA number 3797 of 2026. The learned counsel for the petitioner has submitted that the petitioner is in custody since 14 to 2026 and it is likely that charge sheet will be submitted by 15/5/2026. counsel for the state is directed to file counter affidavit along with criminal antecedent report of the petitioner. And the counter affidavit should clearly state as to whether the charge sheet has been submitted. Post this case on 17th. 17th. 17th holiday. 15th. अच्छा 15 नहीं हुआ.
उसके अगर नहीं हुआ
अच्छा ठीक है 15th.
Item 8, BA 3802 of 2026.
Credit for the husband within 1 year he committed suicide.
गंदा भी allegation. BA number 3802 of 2026. The learned counsel for the petitioner submits that the petitioner has been falsely indicated in this case and he is in custody since
But the date is wrongly mentioned in the petition. It is 17/1/26. I wrongly typed.
custody since 17/1/2026.
2026.
And the date of the incident is the learned counsel submits that the victim has ultimately died in the hospital.
अंदर में सुसाइड कर
जो सुसाइड करके वो दूसरा केस से कंफ्यूज हो गया.
सुसाइड कर
Yes. The learned counsel for the state has opposed the prayer and has submitted that the petitioner is the husband and there is allegation of demand of dowry and she was found hanging. She was found dead in matrimonial house within 1 year of marriage. Considering the allegations made against the petitioner and the victim wife having died within 1 year of marriage in matrimonial home, this court is not inclined to enlarge the petitioner on bail, hence rejected.
Item 9, BA 3808 of 2026.
5% के झाड़ा में ऐसा मीटिंग है
क्या चीज?
ये
एलिगेशन तेरा पढ़ी?
एलिगेशन तो है मिलो एलिगेशन
बहुत गंदा एलिगेशन.
मैं बोले कि ये डायरी में
डायरी में क्या है?
नहीं ये उसमें आ गया ना मिलो ये लीव रिपोर्ट आएगा ये सब आएगा
कोई इंजरी नहीं है.
नहीं इंक्लूड में पे इसीलिए
आप ये देखिए ना पेज 20.
हम देखें मिलो ठीक है भैया हम देख इससे ये डायरी में उसमें आ जाएगा
तो जाके मर भी गई. कोई
नहीं नहीं जिंदा
नहीं. अच्छा
बोल रहे चकनाचूर कर दिया लेकिन ऐसा इसीलिए
आप देखिए ना पढ़ी ना.
हम पढ़ने लगा
पढ़ने लायक नहीं है ना.
नहीं
बहुत गंदा है. पढ़ने लायक नहीं है. आप हस्बैंड है ना.
नहीं
आप ही के ऊपर डायरेक्ट डालिए.
एक ही हस्बैंड है हमारा 65 इयर्स ओल्ड है मेरा
बहुत अच्छा बात.
वैसे 65 साल पे 35 इयर्स का वाइफ है मेरा
बहुत अच्छा बात. 65 साल के 35 इयर्स की वाइफ है.
यही है
ये नंबर 3808
मैं परमिशन टू ड्रॉप है बाइक
After some argument, when this court was not inclined to enlarge the petitioner on bail, the counsel for the petitioner seeks permission to withdraw this bail application. Accordingly, it is dismissed as withdrawn. बहुत गंदा.
हम बोलो इससे हम पढ़े पर इसके लिए पढ़ना चाहेंगे
पढ़ने लायक है.
साइड कर
Item 10, BA 3809 of 2026. Item 11, BA 3816 of 2026.
क्या देखना है? इलेक्ट्रिक शॉक से नहीं मरी है. क्या इंजरी होगा? इलेक्ट्रिक शॉक में क्या इंजरी होगा? बताइए. जबरदस्ती वाला कॉम्प्रोमाइज किए, लड़ाई झगड़ा फिर यही सब काम किए. एट दिस स्टेज करते हैं. किसको बुला लेते हैं?
टाइम नहीं
नहीं,
हाँ बुला लेते हैं लोग तो नहीं करके
कहाँ पे मरे? कहाँ पे मरे?
घर पे अपना ससुराल में,
घर पे नहीं मरे।
ससुराल पे वो इसमें इस तरह से कोई डिस्क्रिप्शन
Died
नहीं
in
है।
accidental
Place
death
of occurrence-
in electric wire fence in the
Yes,
field.
वो
Field में।
बोला जा रहा है कि घर के बगल में इनकी ऑर्डर तो कुछ नहीं बता रहा है प्लेस ऑफ ऑफेंस क्या था। इलेक्ट्रिक करंट इसके घर के आसपास था जो नाली छुई उससे मरी ये इंफॉर्मेशन मिला उन्होंने को देखा उसके पहले टॉर्चर हुआ फैंटेसी हुआ दैट हैज ऑल कम इन डॉक्टर एफआईआर।
That's what I am asking for this line of answer.
Learned counsel for the state is directed to file a counter affidavit in this case and serve notice upon the informant of the case. चार्जशीट हो गया आपका 13-2 से आप 3, 4, 5. The counsel for the state is also directed to furnish to produce the case diary of the case. Post this case immediately after summer vacation on 9th of June.
Item 12, BA 3824 of 2026.
As per the allegation in the first information report, the informant received information from the senior officials that complaint was registered at Hyderabad by various victims regarding commission of online financial fraud. Thereafter, the police personnel found the location near Vaishnav.
आप मास्टर ट्रेनर हैं?
नहीं,
ऐसा लग रहा है, ऐसा आया है।
एंटीसीडेंट कोई नहीं।
अभी मास्टर ट्रेनर का क्या है?
हमारा नहीं है, मास्टर ट्रेनर दूसरे हैं।
आप एक सेकंड, शिवानंद सिंह।
आप
देखिए
ट्रेनर हैं
आप-
आनंद
नहीं, आनंद कुमार
के डायरेक्शन पे बोलते हैं कि वो ट्रेनिंग देते हैं। हमारे अगेंस्ट में कोई एंटीसीडेंट नहीं है और सिमिलरली सिमिलरली सिचुएटेड 4 accused persons have been granted bail by your hospital. These are the orders. As per the allegations, I was apprehended along with 10 other accused persons from my position, mobile phone and ATM cards and other cards were recovered. From them also mobile phone and cards were recovered. Charge sheet has already been submitted in this case from 17 to 2026 and I am having no antecedent mentioned in paragraph number 19 of my bail application.
आपके पास से क्या रिकवरी है?
मोबाइल फोन बोलते हैं, कार्ड डेबिट कार्ड्स रिकवर्ड है। कोई विक्टिम नहीं है। हैदराबाद का बोलते हैं कि वहाँ विक्टिम्स लोग कंप्लेन किए हैं, कोई विक्टिम्स टर्न नहीं की है अरेस्ट करने के लिए कि मेरे बैंक अकाउंट में कोई पैसा नहीं आया है।
Counsel for the state is directed to file counter affidavit along with criminal antecedent report application. Let the case diary be called for from the concerned court.
इसमें और भी कोई पेंडिंग है
और लोगों का भी टैक्स
बताइए, बाकी लोग का कब?
4 लोग का तो बेल हुआ जो हम देंगे।
बाकी ये नाका सेवा का जो पेंडिंग है
हाँ, ये बताइए तो इसका एक BA नंबर 2200/26 नाका राजू करते हैं।
नाका का तो बेल ऑर्डर हम दिए।
नाका का बेल ऑर्डर एक 13 तारीख को भी है एक मैटर सचिन कुमार का,
तो उसी के सब
उसी के रख देते हैं।
क्योंकि इसमें डायरी आ ही गया।
को अभी केस डायरी कॉल फॉर नहीं करना है, बाकी काउंटर एफिडेविट एंटीसीडेंट रिपोर्ट post this case along with the case of co-accused namely Sachin Kumar in BA number 2380 of 2026, which is already posted on 13/5/2026. Isn't कल वाला ऑर्डर अपलोड हो गया,
हाँ चलो भेज दीजिए।
हम इसीलिए वो पूरा एम्बॉस ही करते हैं, वो डीसी रास।
Item 13 BA 3825 of 2026.
नया क्या है इसमें?
This case noted the 3 witnesses, charge has been framed and 3 witnesses have been examined. The lordship, the informant who is also examined in another ST number, he is stating that one of namely
अब दूसरा एसटी नंबर में हम इनका एविडेंस को यहाँ पढ़ें।
no, I am not therefore I have not alleged.
Therefore, I will expedite your trial.
I have not alleged order. Only 1 minute. Because the informant is stating that he got information from the Bajrangi Prajapati, and Bajrangi Prajapati is also examined as PW3, and he has been declared host. And out of 11, 3 has been examined.
Custody कब से?
Custody says 2/12/2023.
Witchcraft हुई है ना?
Yes, sir. Right, there is no any eyewitness. Informant is also not
वो
alleged.
अपने परेशान है, आप क्यों ज्यादा परेशानी उनकी बढ़ रही है? यहाँ बोलिए।
Informant is also not an eyewitness, and nobody is the eyewitness.
BA number 3825 of 2026. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that though the bail application of the petitioner has been rejected repeatedly earlier, but one of the important witnesses has turned hostile. He has further submitted that there is no eyewitness to the alleged offence. So far as and submits that the petitioner is in custody since 2/12/2026. With respect to the state of trial, he has submitted that 3 witnesses out of 11 have been examined so far. The learned counsel for the state has opposed the prayer and has submitted that the allegations against the petitioner are of very serious nature. After hearing the learned counsel for the parties and considering the fact that the bail application of the petitioner was rejected earlier, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the trial court. Next date पता है कोई? Counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director.
Item 14 BA 3826 of 2026.
Allegation as per the FIR is that the petitioner who happens to be the giver of the informant matter entered into the room of the informant and thereafter he committed rape upon her. And when the children inside the room had raised her voice, then the family members came there, in-laws came there. They have bolted the door from outside, and thereafter they have informed the villagers, and in front of the villagers they brought.
You were caught red-handed inside the room
Surprise.
of the lady.
That is there, I'm not disputing that. Actually, the story is that after the death of the husband of the informant, the petitioner and the informant were in love relationship, and on the alleged date of occurrence, they have found in an objectionable condition, in front of the in-laws, and thereafter the in-laws have informed the father of the.
चाकू मिला?
नहीं,
चाकू?
कुछ नहीं मिला. Surprisingly, even doctor has examined the victim, who has categorically stated in the medical report that the victim was not sexually assaulted. And one more thing, during the investigation,
आप कौन है इसमें? Informant? आपको क्या बोलना है? लगता तो है कि पकड़े गए तुम.
नहीं, ऐसा नहीं. बहुत तंग कर रहा था. Personally, as being there, he is harassing like any. He has 2 children and 3 children, and he was used to abuse her and also torture. And on the date of occurrence, he has committed rape upon her. So which was known to he was caught, and thereafter this case has been registered. It is not a case of consent.
There is inordinate delay of 10 days in lodging of FIR.
A lady having 2 children, what can she do? After death of her husband, she is alone in her house, and all entire family members are.
And
Heard the learned counsel
In the
appealing on behalf of the parties. The learned counsel for the petitioner has submitted that
Villagers have
though the petitioner was caught inside the room of the victim and was bolted from outside when he was caught red-handed, but after the death of the husband of the victim, she was in love relation with the petitioner, who happens to be her brother-in-law. He has submitted that the petitioner has been falsely implicated in this case. The learned counsel for the informant has opposed the prayer and has submitted that there is no such love affair. Rather, the petitioner has been raped, as has been alleged by her in the FIR itself. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, as is apparent from the FIR itself, the petitioner was found in the room of the victim and upon being found, he was bolted from outside. This court is not inclined to enlarge the petition on this.
I may be allowed to place one more thing, my lord, that is very important in this case, my lord. That from the FIR itself, it appears, my lord, that the in-laws were present at the place of occurrence, but they have not been made the witness, my lord, in the case diary. And even the doctor has categorically stated that the victim was not sexually assaulted.
Item 15.
The case of cybercrime, I would like to submit one thing. He was neither apprehended at the spot nor there is any recovery. I have preferred anticipatory bail. My bail application was refused. I have voluntary surrendered. My name is transferred in the confessional statement of the apprehended to accused persons. They have been granted bail. There is no recovery millers.
You are in custody only from 2/4/26.
That is evidence, but there is a requirement to verify the antecedent millers. Only without इसमें
अभी तो यही नहीं पता ना आपके अगेंस्ट में क्या आएगा.
लिखे हुए हैं तो
आप लिखे हुए हैं स्टेट का क्या स्टेट का शॉर्ट टाइम नहीं 2-4 से आप कस्टडी में है. ये स्टेज ही नहीं है. आपको इतना जल्दी बेल मूव ही नहीं करना चाहिए. साइबर ऑफेंस में इतना जल्दी बेल हो ही नहीं सकता. जब तक चार्जशीट नहीं होगा तब तक क्या होगा.
मेरा एक सबमिशन है. इसमें हम मेरे अगेंस्ट में देयर इज नथिंग और आई वाज नॉट माय लॉर्ड.
अभी हाउ डू वी एज्यूम कि आपके अगेंस्ट में कुछ नहीं है. अभी तो इन्वेस्टिगेशन चल रहा है.
दिस इज अपरेंट फ्रॉम द FIR.
FIR इज नॉट एनसाइक्लोपीडिया. अभी तो आपके अगेंस्ट में चल रहा होगा ना इन्वेस्टिगेशन.
देयर इज अ रिकवरी एंड दे हैव टेकन द नेम ऑफ दिस पर्सन. दैट इज देयर.
साइबर ऑफेंस में जब तक चार्जशीट नहीं होगा तब तक कुछ नहीं
ये है वॉलंटरी सरेंडर मिनट्स.
बहुत मेहरबानी है आपकी. आपने वॉलंटरीली सरेंडर कर दिया. नहीं, it's too early. It's too early. 2-4 को
because my humble submission is that viewers, इसमें जिनके खिलाफ जो पकड़े गए स्पॉट पे, the persons who were apprehended spot, there is a recovery alert from their position alert. From my position there is no recovery, only confusion there. So that alerts अब time में भी granted alert, जाएगा भी called for.
ये आज इसमें साइबर क्राइम करने के लिए बहुत दिमाग लगाया गया. अच्छा खासा KYC, access ban.
Who accused against her? That is against the accused. Against me,
Or the learned counsel appearing on behalf of the parties. Counsel for the petitioner submits that the petitioner is in custody since 2/4/2026, and there is nothing against the petitioner. He has been made accused only on the basis of confession statement of co-accused. The learned counsel for the state has opposed the prayer and has submitted that it is absolutely premature to say, in as much as the charge sheet against the petitioner has not yet been submitted and the and investigation is still going on.
After vacation.
At this stage,
after
vacation में कुछ नहीं होगा.
After vacation एक डेट दे दिया
नहीं,
दे देगा, एक लंबा डेट दे दिया. लास्ट में आफ्टर वेकेशन के अंतिम टाइम में दे दिया जाओगे.
At this, the learned counsel for the petitioner has submitted that the matter may be posted after some time, so that by that time the charge sheet, if any, is also submitted. At his request, posed this case on 30th of June. The counsel for the state is directed to file counter affidavit along with criminal antecedent report of the petitioner by 25th of June, and also indicate as to whether any victim has been identified and charge sheet has been submitted. And further, if any case has been registered against the petitioner in any other location in India or outside India. पता लग जाएगा आपको?
Item 16, DF 3829 of 2026.
Petitions section 82, 85, 89 and 85 of BS and 3 and 4 of documentation. The petitioner is in custody since 28/4/25. The case is that on 25/4/25 at 2 a.m. the son-in-law of the informant, Devi Nandulas, his father, mother, brothers and their wives, all collectively with the intent to inflict injuries, various injuries to the, they inflicted various injuries to the daughter of the informant. And on 30th/4/25 she died. Maybe there is no specific allegation against the petitioner. And he has been implicated just because he is the husband. Because in the FIR, if it may be seen, the words as all collectively, all intended to till after marriage accused persons were demanding for dowry.
That's a motorcycle. She died out of injury, isn't it? That is the cause of death. Injury is the cause of death.
And lack of treatment.
Sorry?
Lack of treatment.
Lack of treatment. She was taken to the hospital. She died in the hospital only.
Because of poverty, it seems.
In course, no, Southern hospital. Not because of any
A
poverty.
selfie, they were referred to a selfie hospital. And the informant.
मैडम अभी सुप्रीम कोर्ट का जजमेंट आया है इस तरह के केसेस में बेल नहीं देने का. शादी को कितना साल?
She was married in the year 2020.
And died in 25. Third, the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner has been made accused in this case only because he happens to be the husband of the victim, who is said to have expired on account of injuries suffered by her during course of treatment on 30/4/2025. She has submitted that there is omnibus allegation against all the co-accused, including the petitioner. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner and other family members with regard to demand of dowry and torture of the victim who was assaulted, which ultimately became the cause of death in matrimonial home. The marriage was solemnized in the year 2020 and she died on 30/4/2025. It further appears that the trial is going on and one witness out of 7 has already been examined. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner in the FIR itself, who happens to be the husband of the victim who succumbed due to assault, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court, so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the directives.
Also case from supplementary list item 2 DA111822 of 2025.
हाँ सर, अपना बहस करें। कोई बात नहीं सर, स्टेट नहीं रहेगा तो ऐसा थोड़ी है कि आपको बेल नहीं दे सकते।
Just wanted to know whether the seizure of video
Yes.
was not, obscene video was. There is paragraph 35 minus of the case.
Of the?
Yes, that.
Yes. Yes.
पर्यवेक्षण टिप्पणी में दिए गए सचिव सच के द्वारा आलोक प्राथमिकी अभियुक्त द्वारा तहसील कुमार सचिव सच के द्वारा आईडी में पोस्ट टेस्ट स्क्रीनशॉट की प्रतियोगिता के पिता कमलेश प्रजापति के माध्यम से प्राप्त किया, साथ ही गहराई से छानबीन कर साक्ष्य संकलन हेतु वादी की उपस्थिति में अन्य ग्रामीणों से इस बात की जानकारी प्राप्त है कि पिता का अपना फोटो किसी अन्य के मोबाइल में उपलब्ध है या नहीं। काफी प्रयास के बावजूद आपत्तिजनक वायरल पोस्ट के संबंध में अन्य ग्रामीणों के मोबाइल में नहीं मिल सकती।
It was not circulated. Yes.
And what is the photograph that is there? This one.
There is an allegation that there was a circulation of video.
Yes.
But there is no video recovered. फोटो है, फोटो भी ऐसा कुछ भी नहीं है।
Yes.
पैरा 35। नहीं, हम भी घर में भी देख रहे थे, कोई वीडियो नहीं रिकवर।
वीडियो नहीं है,
जबकि एलिगेशन यही है कि इनका वीडियो वायरल कर दिया। क्या है 26 में?
एक साथ सर्कुलर हुआ है, पैरा 23 और 26 और 23
Statement is there.
पैरा 20
पर 26 में साक्ष्य संकलन
पढ़िए, ई साक्ष्य
घटनास्थल
घटनास्थल।
This is the case of occurrence of house of Neha Bhabi.
हाँ.
They had established.
They had gone to the house of Neha Bhabi to have physical relations. यही तो है allegation, कहानी यही है।
On the call of victims.
आप हमको बताइए कोई वीडियो रिकवरी है क्या? नहीं। 26 में कहाँ लिखा है कि वीडियो रिकवरी है? पढ़िए, पैरा 26 तो घटनास्थल है।
स्टेटमेंट ऑफ विटनेसेस और फिर 24 एंड 24
ये तो पीड़िता का है, लेकिन आपको कोई वीडियो भी तो मिलना चाहिए ना एज एविडेंस। 35 says that they tried to find out from the neighborhood.
में इंडिपेंडेंट विटनेस है, साक्षी किरण। लोगों से पता चला कि इनकी बेटी दुर्गावती कुमारी या किसी रोशन कुमार के द्वारा अश्लील वीडियो में फोटो अपलोड किया गया। जब ये अपनी बेटी से पूछताछ कर रहे तो बताएं कि एक बार नेहा भाभी मुकेश कुमार की बेटी से बातचीत होती थी, हम दोस्ती थी, उनके द्वारा इनकी दुर्गावती आय का प्रमाण पत्र बनाने के लिए अपने साथ लेकर नगरदारी गई थी, जहाँ कोर्ट के पास किसी अजीत कुमार नामक प्रज्ञा के दुकान में को रोशन कुमार नामक लड़की के द्वारा प्रमाण पत्र बनाया गया और इनकी बेटी का मोबाइल नंबर ले लिया, जिसके बाद ये मैं दुर्गावती कुमारी मोबाइल नंबर इतना मैं रोशन कुमार मोबाइल नंबर से फोन कर बातचीत करने लगी। रोशन कुमार के द्वारा मसला में शादी करके जाकर मिलने के लिए बोला, तो सारी खबर मैंने दी और रोशन कुमार ने आया कि
hearsay.
इन्हीं में उसी कमरे में की बेटी को एक बार और यहाँ पे बुलाकर किया गया और बेटी का अपने वीडियो फोटो बना लिया गया। बेटी की बात थी, वो बताई कि मोटरसाइकिल में बनाए गए वीडियो को वायरल करने का धमकी देने लगा, बुलाया, जिस कारण बेटी से मना कर दिया, फोन उठाना बंद कर दी। तो रोशन कुमार अपने दोस्तों के साथ मिलकर इनकी बेटी का वीडियो फोटो को फेसबुक, इंस्टाग्राम, व्हाट्सएप में वायरल कर दिया।
लेकिन कुछ मिला तो नहीं है ना, nothing has been recovered. Custody बताइए।
27 August 2025.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is in custody since 27/8/2025, and as per the allegation, the petitioner had come in contact with the victim and were having love affair, and in the meantime they established physical relationship
इसका
in
काम
the
करते हैं आप सब
physical relationship in the house of one Neha Bhavi. It is further alleged that the petitioner had made video and made the same viral through Facebook. The learned counsel for the petitioner has submitted that no viral video has been recovered during the course of investigation, and he has referred to paragraph 35 of the case diary to submit that only 2 screenshots has been mentioned therein. Does not appear to be any objectionable photo, and even in the neighborhood, nobody was found to have seen the viral post, alleged viral post. He has submitted that apparently there was relationship of love affair, and charge sheet having already charge sheet having already been submitted, the petitioner may be enlarged on bail. For antecedent, the counsel submits that there is no criminal antecedent of the petitioner. The age of the victim on the date of FIR is major. FIR के समय तो major है.
Date of birth is 8/9/2006 as per her certificate.
As per her certificate, her age is date of birth is 8/9/2006, and therefore the petitioner cannot be said to be major on the date of the cannot be said to be minor on the date of the FIR.
She has also stated her age 18 years at the time of causal
17 year कुछ
The learned counsel for the state has opposed the prayer and has submitted that the victim was minor on the date of the first incident, and she was 17 years of age. However, during the course of hearing, the learned counsel for the opposite party also could not refer to any paragraph of the case diary which could show that video, the alleged viral video has been recovered. Except photos in the case diary, there is no viral video. After hearing the learned counsel for the party and considering the requisite facts and circumstances and the custody of the petitioner since 27/8/25 and captive having already been submitted, the petitioner is directed to be enlarged on bail. Culpability filed during court proceedings is taken.
Pastoral case from Delhi is item 10, BA3809 of 2026.
The allegation of abduction was been alleged against this petition. Although there is no specific allegation of abduction and only suspicion has been raised against this petition. And I've seen the petitioner court keeping the victim. And apart from that, it is alleged that on 19, the victim was abducted, and on 21, she has been come back to house. So for the in fact, the victim has not raised anything wrong in her statement under section 180 of BNS as well as 183 of the BNS rules, and for which the petitioner is in
There is, you see, there is a direct allegation against him.
on the suspicion.
No, not suspicion.
According
The victim is the informant of the case.
the victim is the informant and she has alleged कि हमको वो तीन पहाड़ ले गया, तीन पहाड़ से पटवा ले गया,
मुझे रानू मुझे सचिन सर लेकर भागा था और बोला कि मैं जहाँ काम करता हूँ ले जाकर रखूंगा एवं मेरे साथ गलत काम भी किया, मैं किसी तरह उससे भाग कर आई हूँ। यह एलिगेशन। ये नंबर 3809।
One thing I would like to draw your attention. In this case, although the charge has been framed on 7/1/2026, and I am in custody from 22/12/25. But up till now, not a single witness.
That I will do. Heard the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and there has been and the petitioner is in custody since 22/12/2025. Charge has already been framed on 7/1/2026. 22/11/25. The charge has been framed on
7/1/2026.
7/1/2026, but not even a single witness has been examined so far. The learned counsel for the state has submitted that the victim was 15 years of age and she herself is the informant of the case, and she has made direct allegation against the petitioner, and somehow she could run away from the custody of the petitioner and save herself. Considering the direct allegation made against the petitioner made by none less than the victim herself in the FIR when she escaped from the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of the school.
Item 70, BA3840 of 2026.
Earlier rejected motion. Hereafter, lordship charge has been framed under section 69 of the BNS motion, and FIR has been registered under section 96 of the BNS. Out of 7 charge sheet witnesses, 2 witnesses have been examined, including the victim lordship. Then 164 के स्टेटमेंट में वो बोली है कि हमारे साथ इसके साथ लव अफेयर्स था और मैं अपनी मर्जी से इसके साथ कर रहा था शादी करने के लिए।
अभी एग्जामिन हो चुका है। एग्जामिन में भी यही बोली है, हॉस्टाइल है।
नहीं, एग्जामिन उसमें फिर यूटर्न द प्रेशर ऑफ द हाईवे and petitioner is in custody since 16/4/25.
और the learned counsel appearing on behalf of the petitioner. The learned counsel for the petitioner submits that the bail application of the petitioner was earlier rejected on 20/11/2025 in BA number 8196 of 2025. He submits that there is an though there is direct allegation against the petitioner, but the victim had not fully supported the case in her statement under section 183 BNSS. However, she has been examined before the court and has given a different statement. He submits that apparently the victim has given evidence before the court under pressure of her family member. He has submitted that 2 out of 7 witnesses have been examined so far. The learned counsel for the state has opposed the prayer and has submitted that evidence the victim has supported the allegation during her examination before the court. And other witness has also supported the prosecution case. And direct allegation has been made against the petitioner. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner and the fact that the bail application of the petitioner was rejected earlier, and also the fact that the trial is going on, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure that the remaining witnesses are promptly produced. Next date कब है? नहीं पता. Counsel for the state is directed. 16/4/25. लास्ट डेट है ना, नेक्स्ट डेट नहीं पता.
16/4/25 से कस्टडी में है
हाँ लिखें 16/4/25 से कस्टडी.
और चीज वो विक्टिम मेडिकल से डिनाई कर सकती है.
The counsel for the state is directed to communicate this order to the SPO of the concerned district and to the director of the prosecution.
Item 18 BA3852 of 2026.
Earlier was rejected by the court.
When it is available. Title.
Item 19 BA3856 of 2026.
Here for regular base, petitioner is one Bharat Kumar Das, aged about 54 years. From the plain reading of the first information report, which I would like to read it
To
out.
be informant. He is the informant. Bharat Kumar Das. ये page 52 क्या है?
He is one of the accused in the case where the deceased is one Vinod Kumar Singh.
नहीं एक सेकंड पेज 52 में देखिए ना क्या है?
काउंटर केस.
वो काउंटर केस.
हाँ, एक ही परिवार है दोनों. झगड़ गया, औरत लोग भी लड़ा, मर्द लोग भी लड़ा. केस काउंटर केस. हाँ, केस काउंटर केस है. And except 4 is और CS केस नंबर.
आपका FIR की तरह.
पेज 20 में है. राइट कॉपी हम पढ़ते हैं.
तो उसको देख के हमको लगा कि क्या चक्कर है.
Similarly situated कोई
पेज 20
और yes.
FIR बताइए सर.
जी.
पेज 24. आपका नाम बताइए कहाँ.
जी. पूरा केस छोटा सा पढ़ देते हैं.
ठीक.
सविनय निवेदन है कि मैं नेहा कुमारी उम्र 29 वर्ष, पिता विनोद कुमार दास, पता साजन पश्चिम सिंह चाईबासा की रहने वाली हूँ. मेरे पिता के घर में टाली एस्बेस्टस का दुकान है. चूंकि मेरे पिताजी घर पर नहीं, इसलिए दिनांक 19/23 वेरी रेलिवेंट है, वो दोपहर करीब 3 बजे मैं अपने दुकान का बिखरा हुआ मिट्टी कपड़ा को ठीक रख रही थी कि अचानक मेरे चाचा भरत कुमार दास आए और मुझे गाली गलौज करने लगे। जब मैं गाली गलौज करने से मना किया तो भरत कुमार दास उनके परिवार के सदस्य और मेरा सामान मिट्टी झगड़ा उठाकर रोड में पटकने लगे एवं तोड़ दिए। इससे मेरा 10,000 रुपया का सामान नुकसान करते हुए उनके परिवार के सभी लोग राधेश्याम दास, गायत्री देवी, डोली देवी, राहुल कुमार, गोलू, अनिल कुमार, छोटू, अंजनी कुमारी मिलकर गाली गलौज करते हुए भरत कुमार दास ने लोहे के रड से मेरे ऊपर हमला किया। डोली मेरे बाल को खींचते हुए जमीन पर पटकते हुए घायल किया। बाकी लोग मुझे लात घुसा से मारकर रोड में घसीटा। जब मैं जोर से चिल्लाई तथा अपने पॉकेट से मोबाइल निकालकर अपने पिता को कॉल किया। कॉल करने के बाद उन लोगों ने मेरे हाथ से मोबाइल छीन लिया। कुछ देर बाद मेरे पिता और माँ भाई पहुँचे। पिताजी उन लोगों को समझाने गए तो उनके ऊपर लोहे के रड से बाएं हाथ पर हमला किया, जिससे मेरे पिता के हाथ में जख्म हो गया और खून बहने लगा तथा दाएं आंख में चोट लगा। मेरे पिता को बचाने गई तो मेरी माँ और भाई को पकड़ लिया। उन लोगों ने मेरे भाई के सिर में पत्थर मारा, जिससे सिर खून निकलने लगा। एक रड से लगा मेरे भाई आकाश कुमार पर हमला किया। लोहे के रड से दाहिना हाथ से गहरा चोट लगा और खून निकलने लगा। पीएस रजिस्टर्ड हुआ इस आरोप पर है जो धमकी देने लगे। हम सभी घायल अवस्था में सदर अस्पताल चाईबासा में इलाज कराया। 19/23 को इसकी सूचना दे दिया, थाना में दे दिया। इलाज के बाद मैं नेहा कुमारी आज दिनांक 20/6/23 को आवेदन दे रही हूँ। Now, apparently the person accused named in the FIR to be involved in मारपीट। उसमें से 3 आदमी को सिमिलरली सिचुएटेड एक कोऑर्डिनेट बेंच ने बेल दिया। अब उसके बाद क्या हुआ? The FIR was registered for bailable offence. All the accused persons surrendered before the court of learned Chief Judicial Magistrate Chaibasa and they were allowed to go on bail. Then after 20 days, the father of the informant Vinod Kumar Singh died due to head injury.
Which he suffered.
Yes, huh?
Which he suffered during the incident.
कोई किसी पर स्पेसिफिक एलिगेशन भी नहीं है, ओमनिबस है एलिगेशन। हमने रेड आउट लाउडली।
और ये जो लड़की है ये क्या है?
3 को काटिए एक बार के पेज 45। हुआ क्या? घटना तो 19/6/23 का है। ये 7/7/23 को टीएमएच में भर्ती हुए इंफॉर्मेंट के फादर विनोद कुमार दास, और उसका टाइप कॉपी हम दे देते हैं। वो टीएमएच का डॉक्यूमेंट हम आपको दिखा एट पेज 45। डेट ऑफ एडमिशन है 7/7/2023। 19/6/2023 का घटना है। 7/7/2023 को एडमिट होते हैं और क्या बोलते हैं? हेडेक एंड हिस्ट्री ऑफ स्लीप एंड फॉल एट होम ऑन 10 days ago। तो 10 days ago होने से घटना से करीब 1 सप्ताह के बाद ही गिरे हैं, अपने बोल रहे हैं, और जिसके लिए पुलिस को भी रिपोर्ट नहीं की। तब वहां से स्लिप पे लिखा हुआ है डामा डिस्चार्ज एनेक्सर 3 में, मतलब डिस्चार्ज अगेंस्ट मेडिकल एडवाइस। और उसके बाद ही चले जाते हैं कलकत्ता ट्रीटमेंट कराने, और वहां उनकी डेथ होती है ड्यू टू हेड इंजरी व्हिच ही हैड सस्टेन्ड ड्यू टू फॉल एंड स्लिप बिफोर 10 days ऑफ 7/7 से बिफोर।
ये फादर का क्या नाम है?
जी,
फादर का नाम विनोद कुमार था।
विनोद कुमार। और काउंटर केस में भी एक्यूज से एक्यूज है।
काउंटर केस नहीं है, वो थोड़ा देर बाद लॉन्च
जी।
19/6/29 का है, उसके बाद काउंटर केस का 4:30 बजे।
जी, जो भी हो तो है ही, लेकिन similarly situated since the assault on the head has not been whispered in the FIR. It is
I
not
just want to
alleged against
know. I
anybody.
just want to know
It is only
this
and
this
on
lady,
that,
this Anjali Kumari. Did she also suffer some injury?
yes, सबको लगा है, दोनों पार्टी को
And
लगा
what
है।
was the nature of injury to Anjali?
वो सब सिंपल है, क्योंकि केस डायरी चार्जशीट हो गया है, मुझे ये केस डायरी में एक जगह लिखा हुआ सबको इंजरी और हम लोग एलेक्स भी किए हुए हैं, सिंपल इंजरी दोनों
क्या
पार्टी
बोलना
का।
आपको बताइए। डायरेक्ट एलिगेशन तो है। भरत
कहाँ
ये जो भरत है ये तो इसके ऊपर तो कुछ भी एलिगेशन नहीं है। Did he die because of this injury? From where did we get this?
ये तो अंजलि कुमार है।
अंजलि कुमार को क्या इंजरी? सिंपल इंजरी। सिंपल इंजरी। 307 में तो केस भी नहीं रजिस्टर हुआ। रजिस्टर तो नहीं हुआ 307 में। कब से कस्टडी है सर?
ये हम लोग सब जिसको बेल हुआ और माइसेल्फ 25/11/25 से हम लोग को बेल मिल गया था। उसके बाद जब ये रेड हुआ 302 का हम लोग सरेंडर।
आपको भी बेल मिल गया था?
जी सबको बेल मिला था। लगा है ऑर्डर पेज 28 में देखिए। Learned CJM has been pleased to grant me bail because all the bail offences were available in nature.
Page 28.
ये onwards 29 surrender come 29
BA number 3856 of 2026.
और सदर PS case number
The counsel for the petitioner submits that the petitioner is in custody since 25/11/2025. He further submits that initially the case was registered under section 341, 323, 325, 427, 504, 506/34 of IPC against the petitioner and other co-accused persons. But after 20 days, when Vinod Kumar Das died and section 302 was added, the petitioner and others had to surrender before the court, and thereafter they were taken into custody. He has further submitted that, so far as Vinod Kumar Das is concerned, he has further referred to Annexure 3 and submits that Vinod Kumar Das was earlier hospitalized since 7/7/2023, and he died 20 days after the alleged incident, and there is no direct allegations of assault as against Vinod Kumar Das in the FIR. He submits that the other co-accused have been enlarged on bail by coordinate bench in DA number 1124 of 2026 by order dated 9/3/2026. The learned counsel for the state has opposed the prayer. However, the aforesaid submissions made by the petitioner is not in dispute. Considering the aforesaid facts and circumstances and the fact that the accused have already been enlarged on bail by coordinate bench and charge sheet having already been submitted, the petitioner is charge sheet नहीं हुआ?
नहीं अभी होगा।
क्यों आप कब से कस्टडी में हैं?
हो गया
हो गया है सर। The petitioner is directed to be enlarged on bail.
Item 20, DA 3859 of 2026.
Again, rejected. Instead of the obligation,
So what do you want now?
22/25.
By our stage क्या है?
अभी कोई विटनेस एग्जाम ही नहीं हुआ है, तो उसमें पेड तो सिंगल नॉट सिंगल इसलिए जुडिशियल प्रोसेस 11/1/25
Yes, state. Why the witnesses are not being produced? Read the FIR.
निवडणूक गुलाब विकास स्टूडेंट्स को द सेकंड श्रीमान सुधी के दावे देता हूँ कहना है कि दिनांक 19/12/20 को मेरी बेटी
नाम ले लीजिए. Don't take the name, please.
विद्यालय गुलाब पढ़ने के लिए गई थी, लेकिन मेरी लड़की शाम तक नहीं लौटी तो मैं अपनी पुत्री का कोचिंग करने लगा. कोचिंग करने के क्रम पता चला कि मैंने कोर्स प्रेजेंटेशन लड़की को मोहनपुर टावर के पास से अगवा कर ले गया. मेरी लड़की तुरंत नाबालिग है. मैंने अपनी लड़की के साथ हुई जगन घटना कर सकता है या तो बेच सकता है या उसकी हत्या कर सकता है. गाँव में ही है, इसलिए उसको मैं जानता हूँ.
She was recovered from your house. DA number 3859 of 2026. Third, the learned counsel is appearing on behalf of the parties. The counsel for the petitioner submits that the bail application of the petitioner was rejected earlier in DA number 8121 of 2025 by the order DT.07.05.2026. But the charge having been paid on 22/4/2025 and no witness has been examined so far. And therefore, on the point of custody, since 11/1/2025, the petitioner has renewed his prayer for bail. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner and the victim was recovered from the house of the petitioner. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner and the bail application of the petitioner having been rejected on merits earlier, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. There is no forthcoming explanation from the side of the state as to why the witnesses have not been produced so far. How many witnesses are there? How many witnesses are there? Rashid कितने? Next date कब है? The council for the state is directed to communicate this order to the SP of the concerned district and to the director of scrutiny.
Item 21, BA 3864 of 2026.
Sorry, 2/12?
25.
What is the offence?
Offence under section 27 of DNS. However, charge sheet has been submitted for the offence in section 64 to and 87 of DNS. After submission of charge sheet, cognizance has been taken and case is pending for supply list. We have 5 witnesses, but no one examined of evidence. So both have measure and having affair between them on 30/10/25 दोनों अपने घर को छोड़े हैं और गिद्धौर में ये लोग मतलब आफ्टर मैरिज they are residing at गिद्धौर and from गिद्धौर from the house of कमलेश कुमार गांधी on 2/12/25 both are recovered.
पढ़िए तो जरा FIR पढ़िए.
निवेदन पूर्वक करना है कि स्टूडेंट्स को रविवार को दिनांक 30/10/25 को समय करीब 2 बजे लगभग मेरी बेटी कोडरमा बगला फुसलाकर शादी तक मसा देकर लेकर भाग गया है। गौतम पिटिशनर शादीशुदा व्यक्ति है, उसको पूर्व से पति एवं 2 बच्चे हैं। मैं अपनी बेटी को काफी जगहों पर खोजबीन किया परंतु कहीं पता नहीं चल रहा है। खोजबीन के कारण मुझे थाना में आवेदन देने में विलम्ब हुआ। समाज से खोजबीन करके
बोथ आर मेजर,
क्या बोलना है? 18 years 10 months
क्या एलिगेशन? दोनों जने भाग गए थे, इसमें 2 मेजर भाग गए थे, इसमें क्या एलिगेशन? यस, कस्टडी कब से बताएं?
2025
What the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is in custody since 2/12/2025 and the victim
as per the order
is a major.
yes 18 years 10 months.
He has also submitted that it is alleged that the petitioner was married, still he had taken away the victim and lived with her as husband and wife. Yeah. And the victim was recovered from the possession, was recovered with the petitioner. The learned counsel has further submitted that out of 5 charge-shifted witnesses, not even one witness has been examined as per Imperial Order dated 28/3/2026, and the victim also refused to be medically examined by the doctor. The learned counsel for the state has opposed the prayer. However, the aforesaid submissions which have been made by the learned counsel for the petitioner on the basis of the materials placed on record is not in dispute. After hearing the learned counsel for the parties and considering the fact that the victim was major and it is alleged that the victim and the petitioner stayed together as husband and wife and the petitioner is in custody since 2/12/25, the petitioner is directed to be enlargement.
Item 22, BA 3867 of 2026.
That we are under section 126(2) and 72 of the BNS and section 4/6 of the POCSO. Individual charge framed under section 137(2), 126(2), 72 and 61(2) of the BNS and section 4/6 of the POCSO. And 3 prosecution witnesses have been examined till now, including victim, father and mother. And not supported the case of the prosecution.
Not supported the case of the prosecution.
My
They are hostile.
होटल फादर और जो मदर है उनको होटल करके है और ये पहचानने से इनकार
इन्फॉर्मेट है
इंफॉर्मेंट कौन है?
विक्टिम
विक्टिम का गवाही दिखाई।
हाँ, पेज नंबर 18 मारोट एनेक्स 2.
She has been turned hostile.
नहीं होटल ये होटल नहीं, फादर और मदर होटल की है। ये पैराग्राफ नंबर 7 में बोली है कि वीडियो कॉन्फ्रेंसिंग के माध्यम से पीड़िता को अभियुक्त को विधिवत दिखाया गया, जिससे देखकर पीड़िता का कहना है कि वह उसे पहचानती है लेकिन नाम याद नहीं है।
नाम याद नहीं पर पहचानती।
हाँ,
और एफआईआर में नाम सही बताइए यही रही।
और the learned counsel.
तो अब उसमें है कि एफआईआर में नाम भी बता रही है, जबकि वो कहती है नाम नहीं है, इसमें नाम नहीं है।
Allegation आपके ऊपर डायरेक्ट है।
डायरेक्ट एफआईआर में डायरेक्ट बोली है।
आपका ट्रायल एक्सपेक्ट करा रहे थे। 3 विटनेस हैं, एक डॉक्टर होगा, एक आईओ होगा, खत्म।
और वही पिटिशनर
अगला डेट बताइए ना, विटनेस हाजिर होगा, बताइए अगला डेट, नेक्स्ट डेट पता होना चाहिए ना।
हम पता कर
बीए नंबर 3867 of 2026.
2825 से कस्टडी में होगी, मोर देन 1
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and he is in custody since 2/8/2025. He has submitted that mother and father of the victim have been examined and they have not supported the prosecution case. However, he submits that the victim has supported the prosecution case, but she has not identified the petitioner during her examination before the court. It further transpired that out of 6 prosecution witnesses, 3 were already examined by 17/3/2026. Learned counsel for the state has submitted that the victim has supported the prosecution case and she is also the informant of the case merely because she has identified the petitioner but could not tell his name. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the SP of the concerned district and to the director of prosecution. मेन तो यही है, डॉक्टर एंड आईओ तो आपके कंट्रोल में, इसके पहले ही खत्म हो जाए। आप डेट बताते हैं, अभी उसी दिन आपका कोई आईओ या डॉक्टर आता है।
Item 23 BA 3874 of 2026.
हस्बैंड ने 498 and 307 दी, जबकि 70 इसमें डायरी में भी लिखा था। ये हस्बैंड है, 304 बी का मैटर है। आत्मा में स्लीप करके गिर करके इनका डेथ हुआ है। पानी
Learned counsel for the state is directed to file counter affidavit. Let the case diary be called for from the concerned court. Informant कौन है? The state is also directed to serve notice upon the informant. Immediately after ensuing summer vacation on 9th of June.
Item 24 BA 3877 of 2026.
Yes. Offense section 69 115 to 146 and 35 of BNS. The withdrawal of the cognizance has been taken only under section 69 of the victim girl is aged about 20 years. She is a major girl and this is a case of long consensual sexual relation and only on the denial of marriage from the family member of the petitioner this case has been brought.
Can you read the
Yes. The FIR at page 18. निवेदन पूर्वक कहना है कि सच एंड सच मेरा प्रेम पर्सन देवानंद नेहरू पिटिशन फॉर लॉर्डशिप सो निवासी के साथ 3 वर्षों से प्रेम पर्सन चल रहा था, शादी का झांसा देकर कई बार चित्तूर रोड किनारे सो के नीचे बुलाकर मेरे साथ शारीरिक संबंध बनाया। पेट्रोल उस थाना बेला बेटी घर से ले गए थे और तेलुगु जनरल में शारीरिक संबंध बनाए थे।
Yes, what do you say, state?
That's not the charge that is written under section 69 of the DSS.
Boxer तो नहीं है।
Boxer is
In the pretext of marriage.
हाँ।
काफी दिनों से लव अफेयर चल रहा है।
69 में वो इसी बात को बोला है। और in case of marriage होगा, तो 69 में is the applicable of the agreement.
But she also says that there was love affair between.
तो for pretext of marriage में तो बोला ही बोल ही रहा है 69 में, इसीलिए चार्जशीट हमने 69
दोनों में फर्क है ना। लव अफेयर है, शादी नहीं किया
उसका
तो
misuse-
फॉल्स।
बाद में उसको misuse
ऐसा कोई लॉ है क्या लव अफेयर होने के बाद शादी करना? ऐसा कोई लॉ बनवाइए।
और false conviction कराने से तो
बेल तो बनता है, कन्विक्शन करा के दिखाइए तब जानेंगे।
conviction तो हो जाएगा।
तो बहुत अच्छी बात है, करवाइए। अभी तक क्यों नहीं कराए?
नहीं तो हो जाएगा।
बेल का मौका ही नहीं
चार्जशीट
मिला।
हुआ,
कब हुआ चार्जशीट?
चार्जशीट
कब हुआ? कब हुआ?
मतलब इसने इंट्री ऑर्डर में आया हूँ।
कोई बात नहीं। BA number 3877 of 2026. The learned counsel for the parties are present. The learned counsel for the petition submits that from the perusal of the FIR itself, it appears that there was love affair between the petitioner and the victim, and it is alleged that on the false pretext of marriage, the petitioner has established a physical relationship with the victim. The learned counsel submits that the charge sheet has already been submitted under section 69 of BNS. The counsel for the state has opposed the prayer and submits that in a case of it's a case of false pretext of marriage, and therefore the petitioner it's a case of rape under false pretext of marriage, and therefore the petitioner may not be enlarged on bail. After hearing the learned counsel for the parties and considering the allegation, considering the fact that as per the FIR itself there was love affair between the parties, and the charge sheet having already been submitted, the petitioner is directed to be enlarged on bail. इसमें किसी को एक्यूज नहीं है क्या? कोई नहीं है। तो यहाँ पे एक किसका बेल ऑर्डर इसमें लगा है? इसमें कोई और केस का बेल ऑर्डर लगा है?
Item 25 BA 3880 of 2026.
It is not giving the FIR the name of transfer of this except the petitioner statement as nothing against this petitioner also. There is in custody since 5/2/2026.
So the learned counsel for the state is directed to file a counter affidavit along with criminal antecedent report of the petitioner. Let the case diary be called for from the concerned court. Post immediately after receiving communication on 9th of June.
Under hearing for admission, item 26 ABA 7264 of 2025.
Before your worship, two petitioners, one 72 years old, one 68 years old. They belong to the same family. Their ancestors were the Sevayans. Of a temple group which had some landed properties in the nature of personal lands in the city of Hazari. The allegation is that despite an application for transfer of the personal land was rejected up to the High Court, after a few years, a fresh application was made for transfer of the land, personal land, and that application came to be allowed, and thereafter the land was sold to multiple people. We are the people who are given the power of attorney to two people, owners on our power of attorney acted, and the officers, from the personal officer to the deputy commissioner Hazaribagh, all were involved.
So you are the power of attorney.
No, I am the Sebayat's ancestors who had inherited the property. With the Sebayats.
What is the story of power of attorney?
According to them, when the power of attorney's case was being argued, it was said that you are the main people who did all the bungling. But let me assume that they are equally liable and I am also same. Because I am the owner, I am supposed to know there is an order of the High Court which says it is not transferable. Despite this, you further make an application and the transfer is made. This is the story. Now I have got 2-3 submissions only today. I cannot go really behind the High Court's order and now argue on anything else. There are 2 things which I want to point out. This transfer took place way back in the year 2008. And the FIR has been registered in the year 2025. Though there was a preliminary investigation which was initiated earlier in the year 2015, it took them more than 10 years to file this FIR, lodge this FIR. Number 2, that the transfer of a Khasman land does not happen because the Deputy Commissioner grants permission. It happens because the state government grants the permission, and no one of the state government level has been implicated as of now. Plus, it was on payment of consideration to the state government. There is a fee. Be that as it may, today, when the power of attorney holders came before this court, one was arrested during the pendency of the ABA and one ABA was rejected.
What is the order of
Yes, I will just show you. It is a development because just then one is both the regular bail and the anticipatory bail travel to the Supreme Court. And the Supreme Court was pleased to grant notice, anticipatory bail to the person who was not arrested and regular bail to the power of attorney who was arrested. Now before they took yes, sorry.
Sudhir Kumar Singh and Vijay Pratap.
Yes, Sudhir Kumar Singh anticipatory bail. Vijay
They
Kumar
were
Singh.
the power of attorney holders.
But nothing on discussed on merits. One Sudhir Kumar Singh, in fact, by way of the interim order, he was protected and when the notice was issued. Now, similarly situated was a family member of these petitioners, Uma Sethi, a lady. Her anticipatory bail was rejected by this court on 6th of February 2026. I am not aware whether this has traveled to the Supreme Court or not. But the only argument so far as this is
concerned. And who is she?
She and we are the same family. She is also a Sebai. All of us together have given the power. Brothers. Family member. She was also signatory to the power. So she is exactly similarly. See, her case is similar to my case. Exactly the same.
So
now the answer to this is the rejection has come on 6th of February. The Supreme Court has granted bail on 25th of March after the rejection.
That's to Uma.
To the power of attorney. So that's power
of attorney are basically acting on behalf of you.
Both arguments are possible. When their matter came up, they said, no, you are the people who are.
They are not involved in seeking any permission.
Yes, they were. They were pursuing the matter on our behalf before the Khasman officer and this government. So far as the transfer. It is not that they were only involved in sale of the land after the permission happened, but they were also involved in the power of transfer application.
Were they also involved in the earlier application for
that material not come, that whether they were not involved. The the earlier
So
case.
naturally their action was bona fide as compared to yours.
One can say so, one can say so. That argument was also made that no, you are the mastermind, you have taken over by paying money, but I am not getting it. So today the point is not, is really my custodial interrogation required at the age of 72 and 68 when a matter which relates to more than 15 years old, and you have conducted a plea from 2015 to 2025. Now they will say that you are now, this is in the affidavit I find, but there is a statement that I am trying to sell my movable and immovable property. It is an affidavit in the nature of requisition made for 82.
See, when it comes to anticipatory bail, it is not only whether custodial interrogation is required or not. The nature of the offence and the manner it has been committed and the allegation involved is also to be taken into consideration.
Correct. Now I have a simple answer. The nature of the offence is a transfer of a government non-transferable land. So this, but that's what I'm saying. Now that takes us back 15 years back. Nature of the land is that the government has not, if it was non-transferable, the government, which the state government at the secretary level, no one has been implicated. The government has taken more than around 1 crore of rupees for transferring the fee. So government, one is that it was not transferable because it was not heritable. I have other points to make on that, the earlier High Court, but I can't get over the High Court's judgment at this stage, or any stage for that matter, unless but I can justify the transfer, that there were deeds, etc.
No, you can justify the transfer, but the fact that the rejection order till the High Court was not brought to the notice of the authority, even by you at the time of seeking transfer
The answer
at the
is,
later stage.
I understand the optics are not good. It appears that there is an order which you suppress from the authorities, and then obviously the allegation in connivance with the authorities get an application of transfer application allowed. So this is the sum and substance. The answer to that is that I have that the transfer which was rejected by the High Court was for a part of the land. Further documents were not there when the High Court rejected the orders. We are now referring to an old deed of 51-52, which again is a contentious issue.
Which is alleged to be forged.
No, that alleged and finding it to be forged are two different things. That is registered. Therefore, I'm saying all these things have happened. Now, within these 15 years, or at least for the last 10 years when the plea is going on, they can't now say that he is still alleged. You have conducted a thorough plea, then you should have come up with all these allegations, and in the allegations.
Did you participate when the notices were being issued to you?
According to me, the participation could not have happened because the arrests were being made. Now, the participation is only.
So you had that opportunity. You do not participate.
The opportunity is ACB just arrests people. They will pick up the people.
So do you want to say that it is that section is absolutely redundant and is of no use?
Yes, in ACB it has. I can give examples. If you are make an affidavit where people were called under 35(3), third day they were arrested. I can show that. So your lordships are saying that
you see, once when were these notices issued to you? Where have you mentioned that notices were issued and you wanted to go? It was for you also to say, no, that notices were issued and you did not participate because you were apprehensive that you will be arrested. Nothing.
I just checked on look at fact is absolutely missing. They have said paragraph 30. They said notice. The said notices were issued on 35(3). Whatever in fact such you got the opposite person did not participate. They are saying what at paragraph 30. That paragraph 30 is that only statement where they said that they will be issued and they never participated. I will take that, but they are also issued service. That's what I'm, service is not there.
You have not filed any response to that.
So this is not a writ. We are saying we are
here
at a stage. We are here to say that merely by not answering to a 35(3) notice does not mean my anticipatory bail will be rejected on that.
I know that is not the reason, but the point is that if you are not responding to 35(3) notice, that becomes all the more reason.
Here is a case which is based purely on documents. Nothing is to be done.
So you are not supposed to participate for a notice under section 35.
They have only issued it once. If so, they could have come. Now, is there an assurance if the 35(3) notice is issued? You also have to then look at the practical difficulties we people in the state face. They are 73-year-old or now they have to go to jail. No one wants to go to jail, but it's not such an easy place to go. So therefore, that apprehension, our anticipatory bails have been pending. I approached the trial court in the year 2025. Kindly see the date of rejection of my anticipatory bail. It's September 2025. We are in 2026. Now for everything, I am not to be blamed.
In September 25, it has been rejected.
Yes.
And it is pending since when?
Yes, it is pending from November, again will be fine. Now therefore the Supreme Court was granted protection to other people, and in many cases said you go and participate. If your lordship gives me one opportunity, I'll go and join investigation. Kindly protect me. That is what the nature of what the Supreme Court has passed in the other cases also. That you okay, we are protecting you, go and join investigation, and then come back. If despite that we don't join investigation, sending people to custody for few days, minutes, or
What do you
some,
say?
I can join investigation.
I am strongly objecting to this. Kindly see para 30 minutes he has placed. Kindly see para 32. But in fact, our entire case.
Counter.
Yes, counter.
This is your counter?
Yes. But the detailed facts have been noted in the earlier order. Kindly see para 32. They have been disclosing incomplete, wrong address in the petition filed before the courts. But kindly see para 32 at page 18. All the three persons, there are four successors in interest survivors. One, we have gathered information that she has died, Basanti Devi. But that also we are not able to assume because there is complete non-cooperation. And para 32 I just showed that in respect of aforesaid accused person, one Shri Rajesh Sethi, petitioner number 2, herein and inventory Sethi filed anticipatory bail before learned special judge ACP, which was rejected by the trial court, which is improved. In fact, during the course of investigation, it has revealed that even the addresses mentioned in those anticipatory bail applications are incorrect. But they mentioned some addresses of Calcutta, it was absolutely an incorrect address. Now, my lord, para 41 and 42 may be seen. We have credible information that they are trying to sell their other properties, whichever it is there, and trying to flee. But we have not even been able to get a wink of them, all the three persons. And as far as Uma Shetty is concerned, to the best of our knowledge also, he has not even approached the Supreme Court. She.
I have to answer these.
Power of attorney is concerned. Kindly see that order Sudhir Kumar Singh. When there was an interim protection given, in fact, my lord, we had conceded in the Supreme Court at page 3. Learned counsel for the respondent acknowledged the fact that the applicant has been cooperating with the investigation, and in these circumstances, she submitted appropriate orders. We do that, my lord, in cases where it is to be done.
No, kindly, that's what I'm saying. Kindly come to when.
Not in the case of the petitioner,
yes,
but
yes.
she is the petitioner. Both are the direct beneficiary, but have given in detail the entire sequence. And it's not a first attempt. 1978, their ancestors made the attempt on the basis of their deed of cancellation of 1951. It was detected at that point of time, specifically recorded that that deed of cancellation, one is forced to, even if it is correct, you cannot cancel it once the land has been vested on the Sevayat by permission of the government. And it was only renewed in the name of the Sevayat. After that, when the renewal takes place in 2008, what they do is, because they were to be succeeded as the Sevayats, so they got their names substituted as Sevayats, and then in connivance with the then Deputy Commissioner and Caste Mayor Officer, got their names entered in the records. But this property was around 35-40 crores which they have sold.
Can I answer, Ms. Can I take the anticipatory bail order of
and that is beneficiary.
Sudhir Kumar Singh, is all these sounded.
Can I just come back in 1 minute?
Sudhir Kumar Singh, kindly come to the second page. Your Lordships have come. Second, by an order dated 18/2026, this court issued notice in the incident matter and also directed that no coercive steps shall be taken against the appellant provided he cooperates in the investigation. We have heard learned counsel for the appellant and in support of the appeal and learned counsel. Learned senior counsel for the appellant submitted. The appellant has been cooperating with the investigation and he has also appeared before the IO on 24/2 after the interim order, and thereafter he has not been summoned. That by an interim order dated 18/2, this court had granted interim protection. In the circumstances, the interim protection may be made absolute subject to the terms imposed. Learned counsel for the respondent state also acknowledged the fact that the appellant has been cooperating with the investigation and in the circumstances. So this is one date. That's what I'm saying. Today I am also ready to go. Protect me. The Supreme Court usually passes this order. We are protecting you. Go and appear before the IO and come back. And in the other ACP matters also where the Supreme Court has granted bail or anticipatory bail, same product. All courts in Supreme Court are adopting this way. Now, so far as the merits of matter are concerned, I am not going.
You see, I am faced with an order of accused Uma Shetty.
Right, but
she was also 73 years of age.
But this is after that. This is after
Maybe
that.
after that, but you see.
Because we are talking about a Supreme Court order. Therefore, I'm saying today the High Court's order was a February, March. Supreme Court has granted it a subsequent development. And these arguments, the affidavits which are filed by SCB, these are what I call the fringe arguments. Bail applications, the address is incorrect. What is my correct address then? I have given a specific address as per High Court rules. Same address was given for the trial court. You come and say it is incorrect. Why is it incorrect? I am not able to understand why is it incorrect. Kindly look at the cause title. What is so incomplete about the address? Number 2.
Para 31.
Yes,
In the course of investigation, it revealed that
yes,
Mr. Coitus had given incorrect address
How
of the
is it
residence
correct?
at Kolkata, and at present they are not traceable.
Correct. What is the kindly come to the cause title? Nalini Seth Road, Bara Bazar, Kolkata. If the IO says this is incorrect, it doesn't.
No. Address is correct, but the point is that you are not traceable at that address.
Have they taken steps to issue or get a warrant of arrest or to issue? They have not taken. They just want people to have. Now this argument, this is a very dangerous trend which has started there. Now they are saying.
No, this is the only case I think we have seen that where such an allegation has been made.
There is nothing else. If there is nothing else, then these fringe arguments will come that they have changed their address. They are not. Which anticipatory person will stay and wait for the police to come and arrest? It's very easy for us to say that, oh, you must cooperate, you must. But we are there for the last 1 year. Now, kindly come to this statement. I immerse paragraph 42 at page 24. Now, these are arguments of prejudice that it is stated and submitted. If your lordship has come at page 42, page 24, paragraph 42. As your lordship.
Yes, respondent.
Just
Yes, Mr. Garodia.
Can I just take one more submission before you? This, not only for this case, kindly take page 24, page para 42. For all the cases, kindly take this. That it is stated.
Page number?
24.
24 of contract?
Yes, counter.
Yes, 24.
Yes, 24, para 40. That it is stated and submitted that it has come during the course of investigation that the petitioners were trying to sell out his movable and immovable properties, and it is a great likelihood that if the privilege of anticipatory bail is granted to the petitioners, they would sell out his movable and immovable property. He said. Now the first question is, which is that movable and immovable property I am trying to sell out? Who has told you? These are what? These are statements made by IOs before the trial courts for getting 82s issued. That चल अचल संपत्ति बेच रहे, कौन सा चल अचल बेच रहे हैं? आपको कौन बोला? Any such statement made casually is only to prejudice the mind of the court that I am trying to flee from justice. It is not so. It is not so easy that I needed you to. The IO has said it on affidavit. Let him come and say which is that property where I was trying to sell. Who has given him this information? Just to make a statement, we can't make a statement in the High Court. And the merits, obviously, I am saying merits is one thing that there is an order of the High Court against me. There is a transaction which can be said to be not very clear. It is there are disputes, but the fact is I am 73, 68. Today 15 years have passed. I am ready to go and join hand investigation. Kindly protect me. The power of attorney holders also went one day. Then they were never called. The people who were in custody, they were interrogated one day, never called. If you need me for one more day, I'll be there. But send it. And in the kindly similar, the Sudhir Kumar Singh anticipatory bail. I'm so sorry to take trouble with this, but kindly see, this is routine. Kindly come to page 5 of that. This Sudhir Singh's bail was rejected, and that went to Supreme Court and granted. Kindly come to page 5, internal page 5. This is the submission of Mr. Garodia which is recorded. Now, may I request your lordship to come to in the middle where 35(3) is recorded. He also, just a line above that, he also submits that ACP had issued notice under section 35(3) of the BNS for participating in the investigation, but the petitioner has not come forward and is not cooperating in the investigation. He also submits that in paragraph so and paragraph so it has come that the petitioner in collusion with the other co-accused are attempting to create evidences to exonerate himself as well as to implicate innocent persons, and the petitioner was trying to sell out the immovable and movable property, and it is great likelihood that if privilege or anticipatory bail is granted, the petitioner would sell out his movable and immovable properties and that. So,
Mr. Garodia, one thing I am not able to reconcile. On the one hand, you say that they are faceless.
Yes.
And on the other hand, you say that 35 notice was issued and they did not participate. It can't be both. Either they are traceless or they are not responding to 35 notice.
That I have seen that 30 paragraph 30.
So therefore, you have issued the notice.
Yes, we have issued the notice.
So you have issued the notice. Now they are aware of it because it is contradictory. You can't have it. You can't have both the sentences together.
But madam, they are traceless.
35 notice if they are traceless. Now they are here. You tell us the date when they will participate. We'll keep the matter pending. We'll ask them to appeal because it appears to be contradictory. Yes, please ask them. Please ask them. How do they say that they did not respond to the notice?
Yes, that I'll ask.
Do you have any service report of the notice? रिसीव नहीं करा पाए ना?
नहीं रिसीव नहीं करा पाए हम लोग एड्रेस वेरीफाई
अब आप बताइए कब भेज देते हैं? रिसीव नहीं करा पाए at the given address. I understand that. Quite possible. They are not there at the given address. Whatever be the address.
One aspect is not to ask them to appear, but the other aspect not to kindly see the allegations. On the face of it, I want to show the allegations were not.
You see, the point is that at the threshold you had issued the notice.
Yes, I had issued the notice.
Right?
But
and for one reason or the other, they were not traced. Actually, the notices could not be served.
Yes.
So now, once you have issued the notice and the notice could not be served, now I am asking them to appear pursuant to your notice.
But still, we have the power to arrest even.
So therefore, you have the power to arrest. So
Yes.
we give them some protection and ask them to appear on a particular date, and you just whatever you have to collect from them, you just collect from them, and then we'll keep it pending.
That can be done, but we have seen on protection. There is absolutely no cooperation.
आप ऐसा नहीं है, अगर आपको ऐसा लगे कि नॉन कोऑपरेशन है, you can file an IA, we will just dismiss their anticipated.
नहीं, जो आंसर्स के समय में जो है, वो कोई कॉपरेशन एक आंसर के समय में एक
रोज
कॉपरेशन
बुलाइए
नहीं
ना, रोज बुलाइए, एवरी डे, जब तक कि कोऑपरेशन नहीं होता है. Yes, Mr. Sinha?
I am ready to cooperate as many times they call me, but cooperation Supreme Court says does not mean confession. As long as confess नहीं करेंगे.
You just go with whatever documents you have or whatever.
Whatever. We are old age people. Whenever they want us within a reasonable daytime, they call us. We'll be there.
टारगेट तो अरेस्ट करना नहीं है ना, टारगेट है इन्वेस्टिगेशन.
इन्वेस्टिगेशन है, but इसमें of course that we can give more, but the whole thing is this is the entire allegation, like Vinay Chaube's money trail. 3.16 crores we had found in cash which was deposited. All these we believe is related to these three people because they are the direct beneficiaries and this is one of the major.
See, we are just giving you the.
I get it, but I
only to the extent that during interim protection
they will not be arrested and thereafter
they will not be arrested and you just give me the date कब आना है उनका बताइए यहीं से डेट फिक्स करते हैं हम लोग तो we don't leave it to you and जिस दिन वो आए आप उनको नोटिस पे उनको एग्जामिन कर लीजिए और उसी दिन उनको डेट नेक्स्ट डे बता दीजिए कल आना है परसों आना है whatever date ईमेल दे देंगे वो और क्या चाहिए because they are not residents of Jharkhand. Are they? Are they residents of Jharkhand?
They are saying that they are residents of Calcutta. Disclose the address of Calcutta, and those addresses are locked, and there are nobody in those addresses. Kindly see.
Here also, what is your?
Here also the addresses are incorrect.
Yes, Mr. What is your address proof?
Yes.
I'll give the address proof. Not sure I'll produce the Aadhaar if that is an address proof. I'll produce the driving license.
Aadhaar, driving license, PAN card.
Whatever. I will give it to the IO. I will give my phone number.
That should have been given in the bail application which has been filed before the court.
It's a matter of whether you want me in custody, you want me to do
You just tell us that when will you act.
आधार का जो ये आधार प्रोड्यूस किए थे वो गलत था जो हम लोग उनके आधार के बेसिस पे हम लोग गए
अब आप बता दीजिए कहाँ आधार गलत है ऐसा थोड़ी है
हम अपने केस डायरी में लाए हुए हैं यू कैन
नहीं आप आधार दिखा दीजिए कौन सा आधार आप प्रोड्यूस की कहां से गलत है बोलना बहुत आसान है and I will then ask 2-3 questions to the IO will he be embarrassed.
You may not be able to ask him because I don't do all this. My IO will not forgive you. No, you can't say this that you will ask a question to my
Don't
IO.
cross each other in such a manner.
I am not I am saying that not make a submission that Aadhaar. If
I have stated that
We are not
just a minute. I am saying if you have not met me, if I have been absconding, who gave you my Aadhaar?
You filed it anti-strange of anticipatory day before the Hazaribagh court.
Aadhaar is forged.
And that Aadhaar is forged. The address is forged. देखिए वो Delhi का paragraph.
Address is incorrect or
Yes, incorrect. That was
forged or incorrect.
incorrect ही है. आधार अगर incorrect address के साथ है तो हम ये नहीं जानते कि whether that Aadhaar was a forged Aadhaar or it's a Aadhaar which is limited.
Because when I see the rejection of the co-accused Uma Sethi, it has been recorded that in spite that there is complete non-cooperation.
Yes, here also it's a complete non-cooperation. Same thing, Uma.
You say that they are trestless.
No.
And then you say that 35B they have not complied. This appears to be conflicting.
No, Uma Sethi also we made the same statement that we serve notices which this.
You have not served notices.
Correct. So, no, in this case, one statement should have been more that the notices could not be served because those addresses they were not found or the addresses were found to be locked. Then we have said in para 32 that the addresses even mentioned in the bail petitions were verified and that was found to be incorrect. And that is recorded in our case there. So it's a case of complete non-cooperation from day one.
I have a copy of the Aadhaar. Of the petition number. I may not have been found on the address at that point of time. That does not make my address wrong or my Aadhaar incorrect, forged. And this is the same address which I have disclosed in my bail petition here also.
But let it be next. I'll bring it on the case diary that those addresses were incorrect. We had gone to those addresses.
Please bring it.
Yes.
Please bring it to. Please bring something.
Yes.
Say that the addresses are incorrect.
Yes, I'll bring that. It's there in our case diary. I've read it. We'll give it on next week.
The learned counsel for the ACP has submitted that the address which has been provided by the petitioners in the main petition has been found to be incorrect. He submits that under such circumstances, the petitioners had gone traceless and the notices under section 35B of BNSS could not be served. The learned counsel submits that if the address itself is not properly disclosed, then under such circumstances, then it can be taken that petitioners are not cooperating with the investigation. He prays for some time to file a supplementary affidavit bringing on record the documents or material to show that the ACP had made attempt to trace out the petitioners at their given address and they were unable to find them out, and also the fact that the notices were sent and they returned unserved. Unserved आना चाहिए ना?
हाँ unserved क्या हम लोग कभी physically भी जाते हैं देने के लिए notices. कि हम लोग physically गए भी हैं इसके.
A copy of the Aadhaar has been produced by the learned counsel for the petitioner. Of petition number 1, which is kept on record. आप उनको दे दीजिए.
हम तो पूरा फाइल करेंगे. तो आधार, पैन कार्ड, ड्राइविंग लाइसेंस जो है in support of my address, I will also.
आपका एड्रेस आपका अपना घर है?
हाँ, लग तो आपका घर ही.
You should find it out. If it is your own house, then you can tell it is your own house.
Produce all documents and affidavit next week. I will just record that your option.
It will be open to the petitioner also to file supporting documents to say that the address disclosed by the petitioner is correct.
Yes.
Petition number 1 and 2, they are husband and wife.
Same address, they are brothers.
They are brothers. Okay. Let there be some argument on this also.
Yes.
Because that will disclose your bona fide.
100%.
If that be so, then some protection, because we are seeing, Mr. Garodia, one thing, we are rejecting the cases one after another. But ultimately, the Honorable Supreme Court is granting relief subject to certain conditions and subject to certain satisfaction. So why unnecessarily, why should we reject?
I would have not insisted on those interim protections, otherwise they are the direct beneficiary. When I show the otherwise materials, one is cooperation and leadership set, another is the nature of allegation. The nature of allegations are so writ large in the present case. I'll show that the nature of and the files how it has moved.
Okay.
Lordship, you are having it next week.
When do you want to?
Next week, because I have no protection.
Okay. Next Thursday.
Next Thursday.
ऐसा सोच है हम लोग ट्रायल कोर्ट की तरह हर बेल एप्लीकेशन एंटिसिपेटरी बेल एप्लीकेशन रिजेक्ट नहीं कर सकते।
नहीं, हम नहीं कह रहे हैं, हम कभी भी नहीं कह रहे हैं।
थोड़ा सा जहाँ थोड़ा जगह है तो थोड़ा देने का है। द पर्सन इज एबल टू कोऑपरेट। एक एडवांस एज का भी एक बहुत इंपॉर्टेंट कंसीडरेशन।
Sellers के केस में Malord have granted bail in ACB. Though personally speaking, I believe that the seller and the buyer in those cases have connived together.
Yes.
But then I am not objecting now. We have told them we will not be objecting to sellers like in the cases. But now in the case of rims,
it is not a case of ordinary seller.
This is a case where it is complete.
Yes, I appreciate that. This is not a case
of ordinary seller, and we have not arrested each and every person. In ACB, we have our attempt is being made to take out statements. We are trying 183 like as is done in CBI. It is in cases where we find the allegations are very grave और arrest के बिना वो कुछ बोलते ही नहीं है, तब करना पड़ता है।
Item 27 ABA 7267 of 2025.
ABA number 7267 of 2025. The learned counsel for the petitioner seeks adjournment by 2 weeks, which will fall during ensuing summer vacation. At the request of the petitioner, post this case on 11th of May. तो interim protection तो है नहीं?
Interim protection नहीं है, बटे लोग मिलते ही नहीं हैं।
क्या बात है, आप मिलते नहीं? आप अपना नोटिस देते रहिए।
नोटिस देते हैं, इसमें we have gone even to their house, वो भी है। Kindly see this. Yes, in this case kindly just have a look. इसमें इसका नॉन कॉपरेशन जो है yes, para 17 first kindly see. Notice dated 21/10, 24/10, 28/1 was issued to the petitioner directing him to appear. Never appeared physically. In this content, notice so and so remained unserved upon for the reason that the petitioner was not available at his house, and as such the notice was pasted at the house door of the petitioner.
To the prayer for adjournment, the learned counsel for the ACB has submitted that there is complete non-cooperation from the side of the petitioner, as is apparent from the counter affidavit, and on account of pendency of this anticipatory bail application, the petitioner cannot claim any immunity/protection. It is made clear that there is no interim protection granted by this court in favor of the petitioner.
Can it be 18 June?
Okay, 18.
Item 28 ABA 932 of 2026.
इसमें क्या एंटिसिपेटरी बेल चाहिए आपको?
CIT
You have a very tough.
So there's only one way of taking instructions first, and what is the case? The case is that Jharkhand State Electricity Board wanted to transfer a sum of 9 crore rupees to be invested in Canara Bank. I, being the branch manager of the bank, provided them the account details. Using that account details, the account number, a transfer was made. It turned out that the account was in the name of Jharkhand State Tourism Development Board, which was a fake account. And after the money went to Tourism Corporation, obviously it was a fake account, the money was withdrawn. Now, the role attributed to me is page 35. That's the only role attributed, which is I had this is what they are saying, that I had issued this letter. Kindly see quotation for interest of on fixed deposit. In reference, now kindly read this and therefore it will be clear that this is something who is involved. Dear sir, in reference to your offer letter number so and so, investment so and so, we Canara Bank Hatia NIFFT branch furnishing the rate of interest on fixed deposit for rupees 5 crore and above. Now, if I am asking for a quotation first, and if it is a genuine quotation given by the bank will never give the bank account details because it is just a quotation. So therefore I am saying that this has not been issued by the bank or by my
Bank details in which funds are to be remitted.
It is just a quotation. So here the transaction is not crystallized.
No, transaction stands for.
No, what I'm trying to say is
the moment you transfer, it was for you to transfer the amount, right? And then they transferred the amount pursuant to this, and it went to and that amount has become
what I'm trying to say
restless.
something different. I'm trying to say that this letter itself has not been issued. This is my defense. It is neither my signature nor the bank is issued. This is a fake letter issued by in connivance with the people in Jharkhand State Electricity Board. Kindly appreciate this. Which bank, I'm saying which bank or which company, while making a quotation, gives the details of the bank account. It's just a quotation. Kindly read at the top. Quotation for interest. It is not that where the bank of the Jharkhand State Electricity Board has agreed that we will give it to you and now give us the bank details. It is a formal first letter which the bank, acting on this, a sum is transferred by the employees of Jharkhand State Electricity Board, and I think Jharkhand State Electricity Board employees subsequently have been made an accused. That is what the case is. That if the informant, there was another case for it, where they started, and it was found that the person who started it is actually the culprit. They created the documents. Both cannot run together. CID,
Not the case for anticipation.
this is not the only thing which has come.
Who is for the state?
CID.
CID who applies for CID? Who applies for CID?
Mr. Manoj.
Absent. Heard the learned counsel for the petitioner. Nobody appears on behalf of opposite party.
And you also just give 10 seconds and just take instructions. 10 seconds.
We appear, but we seek instructions and we have to.
No, nothing is written. आप कौन है? Who are you?
Because in similar matter, I am also appearing what's
Proxy नहीं चलता है इसमें. Things which you cannot respond to,
As my
please don't appear.
As my representative.
I think not taking observations in only
Not present.
Not present ownership, only the rejection will not prejudice my.
ABA number 3932 of 2026, the learned counsel for the petitioner seeks permission to withdraw this application and does not choose to press the same. Accordingly, this petition is dismissed as withdrawn. Withdrawal of this petition will not prejudice the case of the petitioner if he surrenders. And
No, you should not make a surrender observation. Now Supreme Court says.
I am not giving you a time frame for surrender.
Yes. If the petitioner surrenders and seeks for
If the petitioner surrenders
and seeks for
legal basis.
साइन कर दीजिए.
Next, other The remaining CBI matters or ACB matters will come on next Thursday, and other bail matters, if there are any, they check कर लेंगे. That will come tomorrow.
एक interim order आज तक की
किसने?
ACB का मैटर था सीएम
Same have seen 29.
interim order आज तक की
The interim order कौन सा serial number?
29 दे दो interim order.
29 पे नहीं है
29 में तो नहीं.
कंफ्यूजन में
और दूसरा? 32.
कल से आया है
32 में भी interim order है.
7th May तक
Close this case on 7. Interim order तो नहीं.
No course is there. Para 11.
Para 11. 10/4/2026. APA 1609.
No,
184.
अब गलत केस नंबर. Are they cooperating?
Yes. We appear. No, we have stayed. We file our counter affidavit. They have appeared, but he has not cooperated with the investigation. That is my specific counter affidavit.
They have recorded our statement. They have stated that I appeared and they have.
बात बताइए. कोई appear हो.
अब ये नहीं कह रहे
चुप लगा जाए.
हाँ.
और चुप रहे.
हाँ तो वही कह रहे सेल्फ इंक्रिमिनेटरी स्टेटमेंट्स के लिए हम नहीं बोल रहे. अब लेकिन ये अकाउंटेंट है. मेरा इनके ऊपर मेन एलिगेशन है कि एफएसएल में मिला है सारा डिजिटल डिवाइसेस डिलीट हुआ है. After
he has to disclose.
And he has to disclose. He says he is an accountant. And when we put him a question that as an accountant what is your duty? Well, I am an accountant. Then we say that you have access to digital devices. So he says I have no access.
जो भी आपका हुआ होगा interrogation या whatever, you must have recorded.
Yes. I have been given it in seal cover to her lady.
For this consideration. That he is not cooperating.
Yes, that he is not cooperating, and we have specifically pleaded in our counter affidavit that we need his custodial interrogation. We want to confront him with the.
Post tomorrow.
Yes.
ये हम रख लें?
For the lady to बोलिए.
कल से आज क्या आया हमारा फर्स्ट की है सारा चीज पहले भी ऑर्डर.
अब हम क्या करें आज थोड़ा सा डीबी हो गया. आज तो पाथर 2-3 तो केस था. I just give a date.
बस
5 पे क्या? वो कल वाला. अब हम क्या कर सकते हैं? Mr. Mehta, you are here. Maybe that I'll post it on next week, Monday, Tuesday. Are you there on Monday, Tuesday? देखिए जो चीज़ आधा सुने हैं ना उसको हम पोस्ट वेकेशन नहीं करेंगे. 11. 12. आपका कौन सा सीरियल?
सीरियल 5 है.
सीरियल 5 को आप मंडे कर.
तो मेरा ट्यूसडे
आपका सब मिस्टर मेहता वाला सारा केस ट्यूसडे क्या है इसमें?
उसमें 49,000 का था वो डिपॉजिट हो चुका है. ऑर्डर में डिफिकल्ट हो चल रहा है. आज सप्लीमेंट्री कल से आज गया है.
अब आएगा आपका नेक्स्ट वेडनेसडे थर्सडे ऑटोमेटिक आएगा. ऐसे नहीं डिलीट.